Good afternoon, ladies and gentlemen, and welcome to Data Privacy Day 2019. Please welcome Kalinda Rayner, Head of Global Privacy and Senior Director at LinkedIn.
Thank you so much and welcome everyone. It's great to see such a good crowd here for Data Privacy Day. And we are honored here at LinkedIn to be celebrating for the second year in a row with NCSA and hosting this wonderful event. So I hope you enjoy the speakers we have lined up. I think it'll be a fantastic learning opportunity for all of us. And with that, I wanted to introduce Kelvin, our Executive Director of NCSA.
Thanks, Kalinda. I want to thank everyone for joining us today at LinkedIn for Data Privacy Day 2019, a new era in privacy. We'd also like to welcome everyone who's with us via the live stream. We really appreciate you participating with us today. As Kalinda said, my name is Kelvin Coleman. I'm the Executive Director of the National Cybersecurity Alliance in Washington, D.C. For those of you who do not know us, the National Cybersecurity Alliance is the nation's leading nonprofit in building public-private partnerships to promote cybersecurity and privacy education and awareness. Our mission is to educate and empower our global digital society to use technology safely and securely. We create and implement broad-reaching education and awareness efforts to empower everyone with information they need to protect their privacy, stay safe and more secure online, and encourage a culture of cybersecurity. I do want to take a moment for the folks in the room, sorry for the folks who are live streaming, those who are with the NCSA staff who happens to be here, please stand for a moment and be recognized. Danielle, Jessica, thank you. Jennifer, thank you. Good. I also want to recognize Russ, my friend and predecessor, who was the former Executive Director of National Cybersecurity Alliance. Thank you for being here, Russ. You know, today's event would not be possible without the support of our dedicated sponsors. We're very grateful to Visa and Verizon, our contributing sponsors. Thank you so very much for all that you do for NCSA. Our participating sponsors, Yubico, Mozilla, Trend Micro. Very happy to have you here. Mitchell from Trend Micro, really great to have Yubico, Mozilla, and Trend Micro as partners. Women in Security and Privacy, the Identity Theft Resource Center, and Call for Action. Those are our nonprofit partners who we love working with. And finally, ITSP Magazine, great partners and looking forward to working with them in the future. We're honored to have such a distinguished group of privacy experts who have quite diverse backgrounds working with us today. Lastly, I want to extend heartfelt, sincere thanks to LinkedIn for hosting in this incredibly beautiful building. We hope all of you will engage by asking questions and taking part in the panel discussion. Our handle at StaySafeOnline will be tweeting. We also encourage you to tweet about the event and engage with us on social media using hashtag #PrivacyAware, which I was told by Danielle, our social media director, that we're viral, you know, we're trending, so that's a good thing. I thought this group would get that, but obviously. All right, at this point, we're going to start and go into our next session. So thank you very much for being with us today.
Please welcome Kelvin Coleman and panelists for A New Era in Privacy.
I know. So we got to cue the claps better. You know, it's really great, as I said, to be here today. Karen and Kalinda are going to introduce themselves and talk about their backgrounds a little bit. And then we're going to get into our question and answer. I really encourage those in the room, you know, if you have a question, please let us know. We're going to have microphones set up on either side of the room. And of course, we're live streaming. And so those who are joining us by live streaming, please send your questions in as well. Kalinda? you please introduce yourself to the audience?
Yes, thanks so much. My name is Kalinda Reyna. I head up the global privacy team here at LinkedIn. And prior to that, I was working at Apple on privacy issues, and then prior to that, Nintendo. So privacy has been an area that I've been interested in before it got popular, and it's nice to see the changes that have happened.
Hi, I'm Karen Zacharia. I'm the Chief Privacy Officer at Verizon. I often say I've been at Verizon forever. I've been there for 25 years, and I've been in the privacy role for about 8 years now.
You know, I once we were preparing for this session, I was so excited because both Karen and Kalinda have such extensive backgrounds and are subject matter experts, and two people who have so much to offer to us today. So I'm very excited. Thank you both for being with us. And with that, you know, we know how recent changes in privacy legislation has really impacted not only our country, but our world. How has recent privacy legislation changed the landscape, and how have companies responded? And Kalinda, let's start with you.
Yeah, I think there has been so much change in the past 5 years in the area of data privacy. So when I started in 2001, we didn't even have data breach laws. And we did have the European directive, but for a lot of US companies, it didn't have much of an impact if they weren't having offices in the EU. So over the past 5 years, we've seen a big shift in terms of the GDPR coming into effect, California now passing its law, and we're seeing other states choosing to pass laws as well. And then we are seeing changes happening in Asia and many other countries that in the past had not focused on data privacy. So for our team, a lot of what has changed is we've had to be even more global than we were in the past. It's not simple enough to just focus on Europe or the US. You've got to be taking into account trends that are happening in Latin America as well as Asia. And it's also very hard to figure out how to apply these laws on a global basis. So that's one of the big changes we're seeing.
I agree with everything that Kalinda said, and perhaps I'll answer it or look at it from a slightly different lens. You know, when you think about the privacy landscape, I think about a number of different external factors that are really influencing what's happening in companies. One is certainly the legislation that you're talking about, and especially for global companies, that's very challenging. In addition, there is you know, I think that consumers or people in general have a growing sense of the benefits and the ways that companies are using data. Somebody was just talking to me about the fact that she didn't go to the Department of Motor Vehicles on a certain day and she went the next day because she could look at a camera and see how long the lines are. And you know, there's just so many different ways that that data is now being used that's helping individuals in their day-to-day lives, that I think people have a sense of that. And then of course there's also some of the headlines that we've seen. And so really a combination of all of those things, I think, have very much impacted the way we do business today.
Yeah.
So Karen, let me pick up there because Kalinda talked about how, you know, she wasn't the popular kid in class a couple of years ago with privacy.
I didn't say I wasn't the popular kid.
Sorry.
I just said that privacy wasn't popular.
Yes, yeah, I interpreted that. That's true. So you talked about how privacy wasn't popular. Well, now it is. And so can you talk to us a little bit about the challenges, though, that organizations are facing adapting to this new privacy era, privacy legislation?
Yeah, sure. You know, it's interesting, in part because there's so much more of a sense, just from people's day-to-day lives about the impact on privacy, that I think that employees have more of an awareness than they used to, right? As long as I've been in my job, we've trained all employees about privacy. We've told all employees that it's their responsibility to protect customers' privacy. But one of the real changes now is that people really get it in a way that they perhaps used to not. And so whether you're talking about an entry-level employee or the C-suite, right? People are very, very focused on privacy. And although you know, they were, I think you would agree, they were focused on it or paid attention 5 years ago, but it's just that much more so today. And, you know, in terms of the challenges, Kalinda talked a little bit about the challenges of operating globally when you have many, many different laws, and that's absolutely true. We also have, just interpreting laws can be a challenge. And so I think we're going to see over time, as different companies interpret laws differently, we're going to see regulators step in and tell us their view of what the law is. And companies will have to be careful to read those opinions and make adjustments as necessary. And then we're all having to staff up more than we used to because there are additional regulatory requirements that we used to not have.
One thing I was just going to chime in on what Karen was saying is one of the big shifts we do see across companies is that data privacy has become something that's not just for the lawyers anymore. And I think that's something that has really developed over the past 5-6 years. It's something that everybody at the company needs to be aware of. And at LinkedIn, we call it a culture of privacy because it's something that it's not just the lawyer's responsibility. Our job is to help interpret the laws, but it's really the responsibility of everybody at the company. And as a data-driven company, that's an important thing for every employee to understand and get a sense of. So a lot of the work that we do here at LinkedIn is to help make sure that everyone feels a part of that culture of privacy and that they're aware of the responsibilities that we have.
So I really have to ask you this question because and it's somewhat of a, I'm not going to say it's an easy one, but one you probably think about a lot. I mean, what should privacy legislation look like? If you could, advise state legislatures and Capitol Hill, because as large multinational companies, you have insights that they don't necessarily have. And based on your experience of implementing and interpreting GDPR and CCPA, what should legislation look like? Karen?
Sure, I can start on that. I often think of privacy legislation similar to a maze, and you can have a really hard maze that has only one path from the start to the finish, or you could have a really hard maze that has several different ways that you can get from the start to the finish. And I think of privacy legislation, and especially federal privacy legislation, like the latter, like the hard maze that has several different ways we can get to the finish line. And for that reason, you're not going to see me say federal privacy legislation must have the following 10 provisions in it. But what I can talk about a little bit is sort of some overarching themes that we think are important. So first, you've heard me say federal. I think in the United States, it's really important that we have a consistent regime. And so that means one regime that applies to all players in the ecosystem that's enforced at the federal level by the Federal Trade Commission. I think it's important that the regime be very flexible. Things are changing so quickly that we don't want Congress to pass a law that next year is out of date. I think it's really important that it have meaningful protections for consumers. So that means that it needs to include provisions that require companies to be transparent in how they use information and what information is collected. It also means that we have to give consumers meaningful choices and not just check the box type choices. And finally, any privacy legislation should have some kind of safe harbor provision in it so that companies understand that if they take certain steps, what they're doing is consistent with the law.
And I would agree with all those. That's a great outline of really what federal legislation should look like. And sadly, it's not somewhere we here in the U.S. have gotten to yet. If you look at U.S. federal laws, we have the Children's Online Privacy Protection Act, we have HIPAA, and we have Gramm-Leach-Bliley, but we haven't developed a comprehensive data privacy law. And then in addition, for data breach laws, we have 48 different laws. So ideally, I absolutely agree, it'd be wonderful to see one law that is operated at the federal level that is consistent and brings the ability for companies to plan throughout the U.S. as to how they're going to comply rather than having to do a state-by-state analysis. And I think that one of the things that any law needs to do is be very flexible, because it's hard to take into account so many different industries. There's not just the tech industry that this would apply to, but the healthcare industry and potentially, many of the other areas, even auto industry, or every industry today touches on data. So this would have to take into account various different technologies, industries, and to do that successfully, you really have to leave the flexibility in And that's where the difficulty is in interpretation. Does each company apply the law? And how do we think about what is transparency, what is choice, and how do we get those concepts across to users in a way that doesn't overwhelm their daily lives? I think that's one of the hardest challenges for those of us in the tech space who truly want to provide transparency and the ability for users to be in control. But how do you do that in a way that is effective and efficient for the end user?
We are going to open it up here to the audience, but I've often thought about this issue early 20th century America with time. Every local jurisdiction had a different time, right? Every state, they sort of ran their own time. In order to make the trains literally run on time, we had to come together and sort of decide, okay, here's what our timing mechanism is going to be. Is that a decent example of where we are in terms of everybody's going to create these sort of privacy regulations, but at some point we need to bring them together so that they're consistent, so that we all understand it. Is that a decent example of how to look at this?
Yeah, I think it's a really good way of looking at it.
Yeah, I agree. I think it's a great way. The challenge with it is we are now dealing with something on a global scale at a speed that is extraordinary, and with a technology that's constantly changing. So, that example is a perfect idea of what we need to do to come together. But in reality, part of the thing that's hard for developing any sort of legislation here is that the technology outpaces it. And so how do you develop something with broad enough frameworks that you can successfully apply across technologies as well as 10 years from now? I think the GDPR did a fairly good job of that by putting in concepts like privacy by design and data subject rights. But we have to be able to, whatever we develop here in the US, have something that 10 years from now can still be working, 20 years from now can still be working, and beyond.
Great. Going to turn it over to the audience now. Any questions you may have for the panelists? And I'm going to ask you to maybe go over to a mic there. Sorry, I'm going to make you do some exercise here. Yeah. Not that you need it. No.
Hi, this is Kiran Mehta. Kalinda, I think you touched upon the global nature, but if you look at both consumers, their data, and kind of the products that we use, they are even more global. Like I go to London, what if I fall sick? Like how do I access my data sitting here? So is there any effort to have legislation which is not just US or federal, but more global? And in the absence of that, how do you see all of this evolve? Like, would it be a big nightmare?
Well, it's interesting because back in when I started getting interested in these issues back in 1996, one of the questions that was coming up was, how do we develop something at an international level, and can all governments come together and solve this problem or not? And the OECD has done work on this. The Fair Information Practice Principles, which are the foundation for anything any of us are doing when we think about a privacy structure, all come from this global coming together of thinking about these issues. But as I think the internet has commercialized, it's gotten harder for all regions to see the issues in the same way and to have the same stake in it and the same concerns. And so that is the ideal solution, because as we were just saying, the train example is wonderful for when you're working across a continent. But what we're really thinking about, if you think of the analogy, is how do you get planes to go across country to country and transport people and follow similar rules in terms of security checks and health checks and all the other things that come into play. So it's where we need to head, but it's a hard place to get. I don't know what your thoughts are, Karen.
Yeah, no, I agree. And maybe perhaps you'll tell me I'm taking the train or the time analogy too far, but right, around the world, we have different time zones, but yet we've figured out what they are and how to sort of operate with different time zones in different parts of the world. Now, there are some places that have, I'll call them somewhat quirky time zones. Sometimes you'll find a country right next to another country and it'll be 15 minutes difference. And perhaps that's, I understand, I'm guessing, this is not my area of expertise, but I'm guessing countries do it because they want to exert some kind of independence and things like that from the neighboring country. But perhaps what we need to try to do in the privacy world is understand that globally, we're not all going to be on exactly the same time. We can't do that. The sun rises and sets in different places, just like there are different sensitivities and different thoughts for how information should be used and the types of consents we have. But at least if we can get it closer so that, you know, we all share some common terminology and we all share some common sense of how the times work or what the terms are so that we can interoperate in a more efficient way.
Thank you.
Absolutely.
Hi.
Go ahead.
Hi there. So you made a comment at the beginning about consumers becoming more savvy about their data themselves and more concerned about their uses thereof. And there was subsequent commentary and discussion about legislation and safe harbor and how you protect the corporation. Those two things, of course, are a bit different. How do you compare those or offset those when you look at your enterprise and the protection of what the person wants done with their data versus protection of the corporation relative to legal liability? Does that make sense?
Sure, I'll go first. I actually don't see them as different as perhaps you do. I think that for consumers to trust companies and to want to use their products and services, they need to understand how their information is used and believe that they're using it in ways that's beneficial to the consumer. So I actually think the two things go hand in hand.
I don't know if that answered the question, but I would agree. I think, safe harbors are typically in the law because companies are complying with other laws, and likely for most of us, that would be complying with the GDPR, which does get to a lot of what both the CCPA and the Washington bill that's being proposed are trying to get to. So I think every company, as you say, Karen, or most of us are very aware of the fact that the trust is to be earned and to be kept. And in order to do that, it's in our interest to make sure that we're in compliance, whether you do that through a safe harbor or through some other way.
We have a number of people who registered and are here simply because they want to know a little bit more about it or in the industry. And we have other folks walking around with little green things under their tag called media. And so if you could introduce yourself, Tom.
Hi, Tom Claiborne, the Register. So Illinois has a law called the Biometric Protection Act, and their Supreme Court just upheld that consumers have a private right to action and that they can bring action against a company for a privacy rights violation independently. Is that something that you think makes sense for a federal law? Why or why not?
I think a private right of action gives consumers an interest in the issue. I think what I've seen to be most effective, though, with the GDPR has been the penalty function that has been put in place. With the high penalties and fines that the government has the right to bring into play, it is what is helping to drive a lot of the change that GDPR has brought about in terms of greater awareness in the corporate world. So I don't have an opinion either way on private right of action. I think the key thing is that any law that gets passed needs to be able to have consequences attached to it.
And I also, I was originally talking about the maze and different ways you can get to the end zone, and I also don't have a personal view either way. I do think that there are times where, well, if what we're trying to do is make sure we're protecting consumers, it's not clear to me that private right of actions always get there and actually help consumers as opposed to more helping the lawyers who are bringing them. But it's something that we certainly would look at.
Thank you.
Sir. Yes, sir.
Hi, Mitchell Kim, Register. I was wondering, as companies building these products, how should we approach informing or educating end members about how things work or what controls they have at their hands? On the one hand, you don't want to implant things in the middle of their core experiences to be interfered with, but on the other hand, you don't want to build help center articles and settings and then just hide it and so they can find it. So I was wondering, what is the right balance to meet in this case?
I think that's a real challenge for any company to think through, because those of us who are creating those materials want those materials to be seen and used. And so we are constantly working with designers and others in the organization to evaluate how effective is our messaging, how is it being seen, are people responding to it, and are we putting things in the right places? One of the approaches that LinkedIn followed very early on was the concept of the layered privacy policy, in the hopes that what that would achieve is get more people engaged with the privacy policy and understanding it in plain English, and then attaching a video to that as too, which is something that actually, in different cultures, when you think about us as a global company, different people are able to interact with that material in different ways. So it's always a challenge, though.
I totally agree with Kalinda. This is one of the biggest challenges that we face, how to get it just right, and sort of not too big, not too small. You provide lots and lots of information, and nobody's going to read it because it's just it's just too detailed. So figuring out how to get consumers really the information that's most important to them is a large part of what my team and I really struggle with. And I often say that one of the hardest things that we do is say something doesn't have to go in a notice. And that's not because I'm saying that we should hide something. It's perhaps because it's so obvious that we shouldn't be clogging up, putting additional words into the notice about something that consumers really understand. Or perhaps it's less important than the really big thing that we think is most significant to consumers. And so getting that balance right is really a challenge for all of us.
The other thing I just want to add, and this goes back to my prior comment about a culture of privacy, is that it's also required us lawyers to not be the only ones saying everything. So we have our team. I have a lot of folks on my team who are non-lawyers, as well as we work with our communications team and our design team, because sometimes you have to get the lawyers out of the way, because we say a little too much that is hard to follow. So sometimes we work with other members of the team to try to figure out, how do we say this in a way people will engage with and understand? So
I don't know of a person in this room who would agree with you that we need to get the lawyers out of the way. I will say, though, working with companies, I often say to people that these companies are working actually very hard to find what I call the Goldilocks Zone, right? Not too big, not too little, just right. To what Karen was saying, you don't want to put stuff in there that's kind of obvious, but if you don't, are you trying to hide it? Just not the case. And as I've dealt with these companies, I just think they're really doing a great job of trying to find that Goldilocks zone, because it doesn't, there's no benefit to them to hide anything. They want to be as transparent as possible. And with that, please, sir, next question.
I just want to say thank you, first off, for hosting and sponsoring today. My question really stems around taking from a legal and privacy standpoint at the federal level. When we look at the confidence around state-level breach notifications or consumer rights, we haven't seen that consistency. So I guess my question really is, what would you say to the audience or folks listening on the streams? Like, what is the call to action to help push the agenda for more of a federal expectation for privacy regulation across the U.S.?
Are you asking sort of how can we get Congress to act?
How can we get Congress to act?
Okay,
that's
great
a very
question.
tough question these days.
No, I'll tell you that since I've been in this job, the privacy job at Verizon, we have supported federal privacy legislation. And that hasn't been true of all companies. Sometimes I've walked out of meetings and I've had people pull me aside and saying, what is it you guys are thinking? I think the tide has really changed on that in the United States. And I think there are a couple of things that are that both make a lot of companies want privacy legislation, but also has, and more importantly, members of Congress really focused on this right now. And I think one thing is the legislation we've been talking about, both GDPR, right? We've had a lot of members of Congress say, hey, if Europeans are getting these protections, or even US citizens when they go to Europe, why not my constituents? We have things like the California privacy law that also has members of Congress thinking about it. And then we have those headlines that I mentioned earlier. And there really is a renewed focus in Washington on this issue. And I really hope that Congress does do something on it during this Congress.
Yeah, and I would reiterate what Karen said. I think the biggest challenge will be the state that Congress is in right now to be able to consider these sort of bills. And I think California, though, passing this law, California was the first to lead the way with data breach laws. And, I think my hope is that we will get to federal legislation before we get 48 different privacy state laws, quite honestly, because that is just the real challenge for those of us who are trying to follow the laws. How can we already have various country laws, which happily, many of them are converging around the GDPR model. So, that will be a real challenge if we don't get federal legislation and instead we end up with state laws.
Once in a Supreme Court case, the Supreme Court said states are the perfect labs for democracy, right? CCPA and other states are coming in with their legislation. I think it's going to force the federal government's hands, right? I think it's going to force Capitol Hill to say, hey, we really have to make sure the trains run on time. So, sir.
Hi, Tim Rouse with the Spark Institute. I guess one of the problems that I'm struggling with is applying a physical world with physical boundaries to a virtual world. And in this terms of privacy, and I wanted to get your thoughts on how that might get itself resolved. If I live in one jurisdiction and I transact with a vendor in a second jurisdiction, but then I travel to a third jurisdiction and I interact with that same vendor, it seems like there's a lot of issues in terms of even if it's at the federal level or the state levels, coming up with what rules apply.
That's actually been a challenge on the internet since its beginning. And when commerce wanted to start online, that was one of the biggest things that people threw up as a difficulty in making it happen, was how could you exist in one place, buy something from another company that existed somewhere else where maybe it was manufactured somewhere else, and how would you hold everyone along the line accountable? And I think that's part of what makes Kieran's and my job very interesting right now, is trying to figure out how do we look across all of these different laws and figure out what applies when. I actually found the GDPR to be a very helpful thing for many companies in that it helped to create more consistency across Europe, and we're seeing Asia and Latin America following similar models. So in that respect, it is a little easier, but that's part of what you just said is part of the challenge of our day-to-day job.
Jessica, Danielle, you'll let me know if someone is has a question online. So thank you. Until then, sir.
Well, we've already picked on lawyers and lobbyists, so I guess I'm hit already. But I'm a benefits lawyer. I'm David Levine. And a question I have is, our space is a space that people don't pay any attention to. It's like $23 trillion of assets that sits there and nobody talks about it. But we face the same challenges that you're talking about on the broad base here. But there's already a lot of laws out there. We're talking about a national standard. But a lot of your businesses, each of you, bleed into different areas. Like take Verizon. Verizon started as a phone company, as a media company, and other types of coverage. As you adapt your areas, what's your thoughts on how do we interact with existing laws? Like in our world, we've got Gramm-Leach-Bliley, we've got HIPAA, we have ERISA, we have all these laws that are acronyms that most people here don't want to hear. But the idea is, how would you see that we can bring things together, given that there's already a bunch of areas with some standards?
It's a really good question. It's something that I've thought a lot about. Karen Zacharia speaking now. If we were starting from scratch, what I would propose is that we have a national law that covered all areas, including what you're talking about. I think it's so important that we figure out how to get to that finish right now, that it's not what I'm suggesting or what Verizon's suggesting. So laws like HIPAA and Gramm-Leach-Bliley, I would leave as is and exempt those services from this new national privacy law that I'm talking about. But if Congress wanted to tackle that also, I'm not opposed to it. I just think that's a pretty big lift.
Practicality matters, I understand.
Yes.
Yeah, I would agree with that.
Thank you.
Hi there, Paresh from Reuters. A question for Karen. So back in June, Motherboard pointed out how the 4 major US carriers were selling location data or sharing it with these third parties that were then sharing it with other companies with sort of lax oversight. Just this month, they found that these practices were still continuing, at least with a couple of the carriers. I mean, what what is the issue? Why is it still sort of ongoing? Why is it taking so long to unwind some of these agreements?
I can only talk as to Verizon, but yes, last summer there were some articles on this issue, and just to make sure everybody understands it, we have certain services, let's say roadside assistance. You have somebody who's a AAA, not to pick on AAA here, but they're a company who we all know. So there's a AAA customer who's on the side of the road who does not have the AAA app. They call into AAA, and as part of the service, the IVR says, are you willing to have your wireless company give us information so we can locate you on the side of the road? If the customer says yes, then a request would come into Verizon for the location of that customer. Same thing basically works for the other three major wireless carriers. So last summer, there was press around the fact that services like what I just used were being misused by some companies. And Verizon went and looked at the protections that we had put in place for these programs. We had requirements in our contracts that that information that was shared only be used for the specified purpose. We, at the time, had only certain use cases approved. And we had hired a third-party auditor to make sure that the information was only being used in the way that we said it should be. And because of the stories last summer, when we looked at it, we decided to basically Verizon decided to basically shut down those programs as is and to redesign it so that the only way the equivalent of the AAA customers' information would be shared with AAA would be if the consents come directly to Verizon. And we notified everybody that as of November, the programs would be shut down. So what happened? We started getting requests for extensions, and we turned Verizon, I want to make this very clear, this is what Verizon did. We turned down virtually all of the requests for exceptions, with one exception, which was roadside assistance. Because we had 4 roadside assistance companies come to us and say, we're just not ready to do this directly with you. This is the winter months. We really feel like there's a public safety issue here. We don't want to be leaving people on the side of the road. So can you please extend us until the end of March? And so Verizon granted an exception, again, only to 4 roadside assistance companies, and everybody else we closed down. And I think that's why you'd see in the recent motherboard story and the accompanying podcast, that they weren't able to get that information from Verizon. So I hope that helps answer your question.
Sean?
Yes, Sean Martin, ITSP Magazine, NCSA, and LinkedIn. Thanks for putting this on and hosting us today. So we have laws and regulations to help the people that want to do right, but not everybody plays by the rules. So for fraudsters and cyber criminals, how important are technical controls to kind of shore up the areas where things are left open, where companies fail to actually meet the laws?
So technical controls are really important. I don't think when you're talking about companies, I'm not sure if you're talking about companies like LinkedIn and Verizon, or you're talking about the third-party fraudsters, but technical
controls. It's the companies that don't follow the rules, right?
Okay, yeah. Technical controls are really important, and it's another big change that I think we've seen over the last 5 or 10 years, where companies now have chief information security officers, and we used to not. And as we were preparing for this, one of the things that Kalinda said to me is one of the things that we used to focus on was the stolen laptop. And that was the issue 10 years ago. It no longer takes very much of my time, and I'm assuming no longer takes very much of your time, as opposed to the bigger issues. And as I said, that's why those technical controls are so very important.
I have 2 more questions.
Hi.
Yeah.
So, sorry, I'm short. So I had a question about, I guess, if you see the law catching up to or understanding the idea of data that is not at the present time classified as like identifying information that might be worth, I guess, like reporting. But if you've heard of some big data concepts like K-anonymity, T-distance, and things like this, wherein combinations of data or metadata about someone can identify them, and whether we will get to a point anytime soon where companies will be required to disclose that or will not be allowed to collect such data on anonymous visitors, et cetera.
I think your question was, are we aware of these new ways of taking aggregate or other forms of pseudo data and identifying?
And do you think that will be addressed or addressable by law, or is that
I think it absolutely
way
has
too
to
optimistic?
be addressed. And the GDPR does segregate the different types and levels of data. So they do talk about pseudo-anonymous data. We are all operating in a world where we're constantly thinking about the different categories of data we're dealing with. And I think any law that were to come into play would have to think about that personally.
The pleasure of the last question.
Oh, thank you. So, hi, I'm Kevin Walsh from Groom, and thank you for your time today. Kind of listening at the messaging that's been going on from kind of corporate America, and even looking at the comment letters they've submitted to agencies like the Commerce Department, there's been a lot of focus on kind of things from GDPR, controlling, processing, permissible uses, getting consent. Where there still hasn't been a lot of discussion is really, and it relates to the last question, kind of what is data? So what data are you covering? What data is in? What data is out? Do you have views on kind of how that should break down?
I think that is a great question, because today data is almost everything, right? So how do you any longer define what is personal data, what is not personal data? So you will find that most companies today are very conscious of the fact that all data it can typically be identifiable. And if you look at our privacy policy or any other company's privacy policy, I think everyone takes some acknowledgement of the fact that this concept of what is personal information versus what is just data in general is beginning to come closer together to just all being personal information. So.
I agree with Kalinda. You have to some extent, you have to look at how the information is being used or who it's being shared with to have I guess a fuller sense of what the protection should be around it. Yeah, I mean, especially in the hands of, as we were talking about just a minute ago, sort of criminals or people who want to misuse data, it is getting more and more clear that data can be, or certain types of data can be re-identified. Let me put it that way.
I knew you wanted something in here, Karen. So. Listen, thank you very much, Kalinda, Karen. And by the way, you see both Jared and Peter listed. The government shutting down impacted a lot, and certainly impacted those two as well. But they were originally scheduled to be here. So the government shutdown even impacted my 16-year-old daughter, who works at a dry cleaner, who had to lay her off for a weekend because not many people were dropping off their clothes. So Peter and Jared impacted by that very same thing. Thank you all so very much for participating in this segment. We're going to have our next session here in one moment. So thank you very much.